Right, I'll hand over to Gönenç now, who's going to give us the legal perspective.
Thank you very much. So on the sustainability matter, obviously, we're looking at a lot of attention and focus on sustainability and competition law interfacing. And we're seeing a lot of discussion in the academic side, also at the practice of it. And we're seeing legal texts being changed to accommodate sustainability goals in competition law better. Whether there is a demand for it genuinely is still being debated. Demand not for whether there's a demand for sustainability at large, but rather whether businesses are truly demanding exemptions from competition law enforcement so that they can comply with sustainability goals better. That's a discussion in the sense that while all these changes are being made in the relevant legislations, it seems one of two things is happening. Either there isn't enough momentum with the private businesses still, and they're not doing their homework, and therefore there is no demand for this kind of a change in competition laws, and we as competition lawyers and enforcers are taking a demand that is non-existent to heart. And first, they need to start, the businesses need to start doing their homework. Or alternatively, what may be happening is that so quickly have the businesses adjusted to the requirements in the sustainability side, and so quickly have they been harbored in the relevant legislations that there's not that much of a mismatch. In any case, there is not an uproar at the moment that is happening in terms of an audible demand from the companies. But in the horizontal guidelines, there is now a new chapter, and the CMA has also done its homework to harbor the potential need for sustainability steps. The new chapter on sustainability agreements in horizontal guidelines have defined 4 broad categories. One has been the agreements imposing restrictions in general, for example, compliance with prohibitions on the use of certain pollutants. Another category in the 4 has been agreements on joint internal conduct, meaning agreements on measures to eliminate single-use plastics from business premises, for example. Also, the new chapter in the sustainability agreements in horizontal guidelines has recognized agreements on database production as a sensitive topic that is worthy of exemption, to the extent databases are being created on suppliers with sustainable value creation, or on distributors marketing sustainably, or even it could be a blacklist of a database. So suppliers that are consistently insensitive about these, or distributors that are constantly employing methodology that is not sustainable, this is allowed. And then you have a category defined for industry-wide campaigns on sustainability, so long as they don't lead to joint marketing of specific products, and so long as it is industry-wide campaigns on sustainability at large. Now, I'm also speaking with a hat on as a member of Board of Trustees of Client Earth. Client Earth is an NGO, probably the most leading NGO, maybe after 1 or 2 more activist NGOs, but definitely the leading NGO on using law as a methodology of fostering sustainability. The NGO really functions as I'll say, a law firm, litigates on behalf of the earth. The client is earth. And there I'm seeing, when we're discussing with certain businesses, I'm seeing a phenomena that I'm seeing also in the secondary legislation, both in the EU and with the CMA as well. And that is that while safe harbors are being defined, we're a bit shy still. And that shyness is almost leading to a situation where we're defining broad categories where no harm to competition can happen anyways. Whereas what you need, obviously, is to recognize that sustainability is such an important goal in and of itself. And without sustainability, there can be no conversation of welfare maximization anyway, that sustainability directly factors into the very heart of the primary objective of competition laws. And therefore, whenever there is a tug of war between sustainability and competition as such, sustainability is going to be granted priority. Whereas with the safe harbor for the sustainability standardization agreements, we don't really see it. So we see that the standard development must be transparent and participative, not a problem with that. It should be on a voluntary basis, not a problem with that. The entities should be free to adopt higher sustainability standards. So you can come up with minimum standards, but entities should be free to use even better standards, fine. There should be no exchange of sensitive commercial information that is not objectively necessary to develop a sustainable practice, fine, we're used to this. And access to the outcome should be effective and non-discriminatory. Up until now, what I have counted is okay. But now I will count two more in the legislation that I feel is showing that still the primary objective is protecting competition for competition's sake. And we're fumbling, we're dropping the ball here at this point. It says it should not lead to a significant increase in price, the measures that are taken, or a significant reduction in the quality of the products in the market. Now, this categorically stipulated as such is not understanding sustainability as it should be understood. Because if there is such an obvious sustainability goal that can be attained only by an increase in prices, and if the entities are actually coming up with an agreement that is fostering that, this may well be subject for rule of reason. I'm not saying categorically it should be allowed, but this here is already creating almost an impression that so long as you don't have any consequences on the price, I'm going to entertain your new age sustainability worries. And that's not good enough. The second one is that it says the combined market share of the undertakings must not exceed 20%. And that's just not going to cut it. This is, and I recognize that I have taken too much speaking time, so I'll wrap up with one personal anecdote. I engage very frequently with companies that we're giving a deadline for sustainability as client. And there is always unmistakably this point where we say by 2028, you should switch to such and such, or else we're suing you. And the entity says, how about 2031? And you want to say, I don't say it, but you want to say, I'll ask the nature. People still do not fully appreciate the fact that it is not other humans that are putting the deadline. There's science behind it, and there are tipping points, and things need to be done. So here we are doing some work on the competition law side, and the safe harbors that are defined are a step, but query whether they're as aggressive as they should be, and query whether they're putting things into the heart of competition law enforcement. But I'm featuring it with the notion that maybe entities are not demanding it anyway. It doesn't look like entities are screaming and yelling for a break from competition law so that they can do so much good in collectively adhering with sustainability goals. I'll gladly talk about CMA's green agreements guidelines a little bit in the next round, maybe for 2 minutes. Just 1 minute intervention, just to underline what has been said. It is also telling, I think, that most people who are applying for a safe harbor in the EU or for an informal guidance with the CMA are foundations and NGOs, and very few private entities are going down that route. Because if they get rejected or if their application gets tweaked, then they're going to be placed under a certain spotlight, and they will be seeing pressure that they still do it, but without the cost, but without the price increase and all that. So if you wanted to survey how many applications there have been and who have done these applications, you will find that a vast majority of them are NGOs applying. And NGOs are very good faith about all this, but without belittling their work, I want to say, when the Fair Trade Foundation applies saying, I would like to promote fair trade in the following way, and when the CMA says, yeah, okay, that's not really, we're not doing anything. This was okay already. Now there's a very recent example of the Worldwide Fund for Nature, WWF, just a month ago, getting the informal guidance from the CMA. And all that is to it is basically they're saying, we would like the participating retailers to pressure certain suppliers to set net zero emissions. It's year 2024. We should be way beyond this. There should be cutting edge ideas coming in from businesses as to how they can reflect the cost of really well thought of sustainability steps into prices, and the fact that they're not hijacking the sustainability goal to be able to ramp up prices even further, and this is necessary, and on aggregate this is good also for welfare and sustainability. And then there's the economic analysis done for it, and the authority says yes, okay, in this specific instance I allow it, then we will have caught a fish in this pond. Otherwise it's basically we're just I think feeling good about ourselves, but we're not doing anything particularly.
Thank you very much.